hearing in the appeal, the application by the Northern Ireland Human Rights Commission and the reference.
And before we begin, Ms. Leven, just to remind everybody here present that the court has made an anonymity order in the following terms. The court ordered that no one shall publish or reveal the names or addresses of the interveners JR76 who are involved in these proceedings, or publish or reveal any information which will be likely to lead to the identification of them in connection with these proceedings or the proceedings in Northern Ireland.
Thank you, my lady. My ladies, my lords, I appear on behalf of the appellants in this matter, together with my learned friends, Miss McMahon and Mr. Blundell. My lady, I'm rather assuming your ladyship does not want me to go through the full order of appearances, but I'm very happy to do so if it would help the court.
We do all have a list.
Indeed. And we've arranged...
And we almost know who you all are. And if we don't know now, we shall know fairly soon.
Indeed. As the court is aware, this case concerns the law in Northern Ireland, which makes it a criminal offence for women who are pregnant by reason of rape or incest, or have pregnancies with severe fetal abnormalities, to have an abortion in Northern Ireland, save in the narrowest of circumstances. Our case is that the effect of those provisions of the Northern Irish criminal law subject women to inhuman and degrading treatment, contrary to Article 3, to an unjustifiable breach of their right to personal autonomy, contrary to Article 8, and discriminates against them on the grounds of their sex, contrary to Article 14. I intend to deal with the matter in the following order. Start with an overview of the factual material, then the relevant law in Northern Ireland, third, the international consensus on permitting abortion in these three circumstances, fourthly, the international law, fifthly, Article 3, sixthly, Article 8, and under the heading of Article 8, I will also deal with the issues that are said to arise under Article 2 and the issue of institutional competence, and then finally, Article 14. My ladies, my lords, I want to start with the facts, because the facts in this case are critical. They show why the impact of the criminal law in Northern Ireland does amount to inhuman and degrading treatment by the state. The facts show the degree of intrusion into women's most personal lives, women and girls. And the facts show the impact on a number of women and girls. The facts fall into two parts. First of all, the evidence from three individuals relating to their experience of pregnancy in Northern Ireland with fetal abnormality, and then evidence from experts in the field relating to the experience of women and girls pregnant by reason of rape and incest. So, starting with fetal abnormality, the court has before it the evidence of three women: A.T., who is subject to one of the anonymity orders, Sarah Hewitt and Denise Phelan, all three of whom were diagnosed with fetal abnormalities.
I think we were told that A.T. is now happy for her name to be used. Is that right?
My lord, it's never been entirely clear to me. Yes, she is, my lord, I'm told.
That's why she wasn't mentioned in the order I just read out.
I'm sorry, my mistake. So, Miss Topping.
Mrs. Topley?
Ms, I think.
Very well.
I suspect it is Mrs, but I've always called her Ms.
She certainly refers to her husband.
Yes, she does. Your lordship is entirely right. Now, in terms of that evidence, obviously there's a very short time for my submissions before the court. So what I intend to do in terms of all three is show your lordships and your ladyships the evidence, point out, as it were, the critical pieces, but I would ask every member of the court to read that evidence in its entirety, because the strength of it lies in the entirety. So if I can start with Miss Topley, which is in Core Volume 2, at page 592, MS 9366. And I'm going to summarise parts of this, but I hope fairly, and obviously the respondents, if they feel I'm being unfair, can point that out. Miss Topley was pregnant, a very much wanted and hoped for pregnancy. And if I ask the court to turn straight to page 597 to 8, one can see halfway down, as is the case with all the fetal abnormality cases, it was only at the 20-week scan, one can see on the left-hand side, that it became clear that there was something wrong with the fetus. And on page 598, she describes what happened at the 20-week scan. Over the page at 599, first full paragraph, the consultant at that stage said that the termination of pregnancy was illegal in Northern Ireland and that we would have to continue with the pregnancy to term. And he then explained the detail of what would happen to the fetus in that period before it died. She goes on to explain much of what happened to her over the next few weeks, and this is part that I do very much ask the court to read. She had a long series of medical appointments, at none of which was she given any hope that she would be able to get an abortion. If I ask the court to turn on at 603, she then, top of the page...
Just remember to give us the electronic page.
Oh, I'm so sorry, my lord. Yes, 9377, so about 3 pages further on.
Thank you very much.
Top of 9377. The doctor then went on to talk about what our next steps might be. She explained that as our baby had a fatal fetal abnormality, termination of the pregnancy would be a possibility, and she would put her name forward to allow for it. And Miss Topley goes on to say that she was surprised because she thought termination for any reason was illegal in Northern Ireland. She was then sent to another appointment. One can see that at the bottom of the page. And she referred that next doctor, it isn't clear whether it's a consultant or not, to what she'd been told. And you can see at the top of 9378, once she'd finished telling that next doctor what had happened, I told her that we decided that a termination would be the best option for us. She looked at me and said, well, that's not going to happen. I was shocked and explained that our appointment the day before, the doctor had told us it was an option. The doctor said she shouldn't have said that. I became very distressed. We'd been given hope that this nightmare could be over, and then just like that, it was snatched away from us in the rudest manner. She then goes on to say that she questioned the doctor about whether the view that had been given was correct. And Ms. Topley said, surely there should be an assessment of my mental health. She, that's the doctor, replied, I phoned the psychiatrist and she said no, she wouldn't sign off for a termination. I was really shocked. I exclaimed, so you've made an assessment of the state of my mental health before you even met me? At this point, she left the room to phone the psychiatrist, came back, and Miss Topley was given an appointment. I questioned her about the terminations that had taken place in Northern Ireland over the previous 2 years. She said they didn't happen. And then there's reference to the official figures. Without reading it all through, it's clear that Mr. Topley by this stage was extremely seriously distressed, unsurprisingly. Over the page, she rang Mary Stopes, which is a reproductive rights organisation that operates in Northern Ireland, to inquire about a termination. They said that they could not help me as I was past the time for self-referral. One of the critical points I'm sure the court has picked up on is that particularly in cases of serious fetal abnormality, it's almost always the case that they only become clear at the 20-week scan. So at that stage, time is very much of the essence to get an abortion. The next week, following paragraph, Ms. Topley then says, I tried to come to terms with the fact that I would be stuck in this nightmare for the foreseeable future. Then she says, the next week, I saw the psychiatrist. She basically listened to me vent about the unfairness of the situation. I'm not sure if she was actually carrying out any assessment with a view to possible termination. She prescribed me sleeping tablets, as I hadn't been sleeping. Then, to put it colloquially, the nightmare goes on. The following week, she had an appointment with the original consultant who explained the condition of the fetus in her womb. He explained that the baby's condition meant that while the baby was in my womb, it could survive through me. The issue was when the baby would be born, they wouldn't be able to breathe, as the deformity of the rib cage meant the lungs could not develop as the heart was taking up all the space. With regard to the remainder of my pregnancy, he explained that there was the risk of the baby's heart stopping, as the heart may run out of room. He explained to me there was a risk that I might develop polyhydramnios, excess fluid, as the baby would not be able to swallow and process the fluid as normal. He also explained he would see me every 2 weeks in order to keep an eye on the baby's heart and on my fluid levels. And then the next paragraph, I left the meeting trying to process the fact that I could potentially be pregnant for at least another 12 weeks, or my baby's heart could stop any day. And she then, my ladies and my lords, goes through the situation she found herself in Northern Ireland. And then at 9381, she, at the bottom of the page, over the weekend of the 3rd and 4th of May, I got really uncomfortable and was in a lot of pain, struggling to walk and move about. I spent practically the whole weekend crying. It turned out that over that weekend, I developed polyhydramnios. This means there was excess fluid, often associated with a malformed fetus. I revisited my GP, who prescribed me slow-release morphine. I was taking 40 milligrams a day, twice a day. And then, 2 paragraphs down, on the 26th of May, when she was just under 35 weeks pregnant, her waters broke. Turned out that the baby had died just before that, and she describes the process of going into labour. And at page 609, she describes what her feelings were when the fetus was born, dead, and what she went through. And then if I can ask the court to turn to page 9385, she says in the second paragraph, this tragic situation was compounded for me by the apparent inability of the medical profession to offer me a termination even in these circumstances. If this had been available, I believe it would have diminished our suffering. Being forced to continue with this pregnancy added to the tragedy. We were not able to grieve for our daughter, even at the time of her actual death, or to start deal with our emotions. This was further compounded by the fact that the medical professionals could not even agree amongst themselves whether a termination was permitted. Can I ask the court then to turn to the evidence of Miss Hewitt that appears in Core Bundle 3, Core Volume 3, MS 9391.
Can I ask, Ms. Leven,
I'm so sorry.
are we to take it that that witness didn't think of seeking assistance outside Northern Ireland?
My lord, the problem for Miss Topley was that by the time it became clear that she couldn't get an abortion in Northern Ireland, she was beyond the 24 weeks.
Oh, I see.
And as I understand her evidence, it was not suggested to. Actually, she might well have met the test in the Abortion Act 1967
Yes.
for an abortion in England. But the evidence suggests that she was never advised of that.
Yes.
But when we come to Miss Phelan's witness statement, you'll see some of the problems of trying to get an abortion that late for a Northern Irish woman. And this is a particular issue. What's become clear through the evidence in these cases is that there are slightly different issues for women and girls pregnant by reason of rape and incest to the women and sometimes girls pregnant with severe fetal abnormalities. Because in the latter case, a woman has a very short time to get an abortion. So Miss Hewitt, again, a very much...
What page is that, please, Ms. Leven?
Oh, I'm so sorry. MS 9391, core volume, first document.
Yes, thank you.
617. Again, a very much wanted pregnancy. Again, it only became apparent at the 20-week scan that there was something wrong. Paragraph 14 on MS 9393, almost at the bottom of the paragraph, Mrs. Hewitt's fetus had anencephaly, which is quite a common fetal abnormality. And one can see at the bottom of 14, we were told that such babies usually die before birth, but if that happened, I would not go into spontaneous labour. Rather, the baby would just remain there until its death was discovered by a scan, which it would suggest was suggested would be done every 2 weeks. Paragraph 15, like Miss Topley, it was explained that effectively her body was acting as a life support system. And she says in the middle, in other words, my baby was not capable of independent life. Since learned that carrying a baby that had died for a time, perhaps for nearly 2 weeks, would have put me at risk of infection. It was explained they would carry out fortnightly scans, and if it was discovered the baby had died, they would then induce labour. 18 and 19, Miss Hewitt explains her efforts to understand the legal position. And 19 is worth reading. One of the things I found so distressing was that we had to get into a legal discussion at a time when we were trying to cope with the full enormity of the fact that after carrying our baby for 20 weeks, we were not going to have the baby we'd been looking forward to. The doctors were really concerned about their legal position, and I now understand why. But at the time, I wanted them to be focused on dealing with me and not their fears about a possible criminal prosecution. And then at 20, she explains that she went on the web, tried to discover more about the condition of the fetus, and at the second half of paragraph 20, she describes the impacts of anencephaly. Effectively, the baby has no skull, which means that the birth process is a particular problem. The final scan carried out by Dr. Sherrard had put it beyond doubt, no bony skull identified. I was just horrified. I do not have the words to express the confusion of my emotions, shock, grief, and the fear that I might lose my life in a very long and dangerous labour, as I'd read had happened to one other mother. Later, Dr. Glenn confirmed that what I had read about labour was true. And then, my lords, my ladies, what is clear from paragraphs 20 through to paragraph 30 is that Miss Hewitt did everything she could to obtain an abortion in Northern Ireland. I'm not going to read it through, but she left no stone unturned. And I want to emphasise that because the Attorney General in his written case at paragraph 3, footnote 1, suggests that Miss Hewitt might have met, or somebody in Miss Hewitt's position, might have met the Bourne test, and I'll come to the Bourne test in a few minutes. But the evidence is absolutely unequivocal that that was not the approach taken in Northern Ireland. And then at 32 to 38, she describes what happened when she got to London and the effects of having the abortion in London. And she talks about the impact of having to go away. She had the good fortune that her mother could go with her, but the effect of having to go away from her support network, of not being able to, the awful arrangements that have to be made if you want to take the fetus back to Northern Ireland to bury it, and effectively the increased trauma that she went through because of having to travel to have the abortion. Just worth noting in paragraph 30, a point which is perhaps critical for the Bourne test. I'm sorry, I should have picked this up a moment ago. She, in the middle of paragraph 30, MSN 9398, she went back to see Dr. Glenn, who was the consultant obstetrician, and he had discussed her case with Dr. Monaghan, who was a consultant psychiatrist, who'd advised that they would be unable to predict significant mental illness in the long term. And the court will understand how critical that is when we look at the Bourne test and the guidance. And then at 54 to 55 in her conclusion, she makes clear the impact on her of having to travel to have the abortion. And the third, so that's Mrs. Hewitt. And then the third affidavit, which the court may not have seen before, is the evidence of Denise Phelan, which was lodged very recently on behalf of Amnesty International. Now, this appears in the intervener's additional documents, which is a slim blue file. And for the MS numbers, it's supplementary MS 105. Ms. Phelan describes what she went through in intense and really very painful detail. One differentiating
It looks like this.
I'm so sorry. And it's, I'm sorry, I should give the reference to those who are following in the hard copy. 8th intervener at the back of the intervener's
105, it's right at the back.
documents. Supplementary MS 105.
Thank you.
And the thing that differentiates Ms. Phelan is that she was suffering from serious mental health problems before she got pregnant, yet still she couldn't get an abortion in Northern Ireland when fatal fetal abnormality was diagnosed. Paragraph 4, she summarises her views on the situation she found herself. She says in the 4th line, I therefore make this affidavit as a woman and to try to convey something of the sheer cruelty of knowing that there was relief and professional help, but not for me in Northern Ireland. I was trapped. The sadness I felt in learning that the fetus I was carrying had a fatal abnormality was completely overtaken by the horror of realising that I had to continue on with the pregnancy in the knowledge that the fetus could die at any moment, and then there would be the awful experience of having to deliver it. I felt totally consumed by the experience of living that horror every day. Even now, over a year on, it's still so raw, and I feel there's no healing for it. I've been changed by it at the most fundamental level. And just to give the court, as it were, the key passages, paragraph 10, she explains how she felt when the diagnosis was given. Paragraph 12, we returned home in a state of overwhelming grief and emotional distress, and in this mental state tried to research everything we could about Edwards syndrome, which is what the fetus was diagnosed with at that stage, and Northern Ireland abortion laws. Spent the following 4 weeks grieving in a constant state of migraine, crying and vomiting while desperately trying to read medical journals online, researching how and where to have a termination. It's truly devastating not only to be faced with the worst imaginable news, but to have that exacerbated by the very fact that I was left in a state of peril without any information other than the internet to try and research how I could lawfully get a termination. She explains in 19 that she had been diagnosed with clinical depression in 2011. She refers over the page to her efforts to try and get a termination in Northern Ireland. And she says in 24, I was referred to a psychiatrist, Dr. Woods, who'd only seen me once before, and he was going on holiday. I listened while the referring consultant, Dr. Bryson, spoke to Dr. Woods. She informed us that he had said no psychiatrist in Northern Ireland would sign off on an abortion. If a mother's mental health was at risk, they would simply treat her condition with medication. And then at 35, to me, the whole experience was both a physical and mental torture. And that really summarises the paragraphs before. Then she goes on to say, it was not just the changes to my body, but also the fact that I could feel the fetus moving. A terrible aspect of Edwards syndrome condition is the fetus is not able to ingest the amniotic fluid to the same extent as a healthy baby. So they swim around in the fluid, meaning they turn over in the womb. I could feel the very pronounced and frequent turning. I'd often have to stop walking and take a breath to allow for a particularly vigorous set of movements. Also, the amniotic fluid increases dramatically, stretching the womb. My whole abdominal area expanded. I looked more advanced than I actually was, which itself drew comment. All of this was an ever-present reminder that despite my apparent resemblance to other pregnant women, I was not like them. And even though there was a means to bring the torment to an end, I could not access it. One of the points that comes out of all these witness statements is the trauma, the humiliation these women were going through because they were walking around Belfast and Northern Ireland, looking pregnant, being pregnant, facing congratulations and, oh, how lovely you're pregnant, all the time knowing that the baby would die either within them or when it was born. That's a feature of all three witness statements. So, my ladies, my lords, 2 points I want to draw out of this evidence. One is the extreme suffering of those women, but the second is the very chilling effect of Northern Irish law and the guidance we will see in a moment on the ability of the medical professionals to help them. I'll come back to this point on a number of occasions, but the Lord Chief Justice, in his judgment in the Court of Appeal, said that women were getting the best medical care in Northern Ireland in this situation. In my submission, if you read these witness statements, you cannot accept that proposition, because in all these cases, these women were being forced to go through physical and mental trauma in circumstances where there was a solution they wanted and which could have been given to them. And
is there any study prior to the change of the law in this country on that point?
Not that I'm aware of is the answer, my lord, but I suspect that it would be very difficult to do because of the whole issue of unlawful backstreet abortions pre the 1967 Act. What the court does have here in the evidence is the evidence of Dr. Dornan, who's was an obstetrician at one of the main hospitals in Belfast, that before the guidance was issued, abortions were carried out on the grounds of fatal fetal abnormality. But not before the guidance, before the Family Planning Association case in 2004. But since that case, I think Dr. Dornan's, affidavit is actually the previous document, supplementary MS 95. And so it may have been that at least some of those three women would have been given an abortion pre-2004. But in terms of my lord's specific point, I'm not aware of any evidence on that. Can I then turn from there to the evidence in respect of women and girls pregnant by reason of rape and incest? Now, unsurprisingly, there is no direct evidence of women who've been pregnant in those circumstances. But there is evidence from two women who are intimately involved with these issues in Northern Ireland, working for reproductive rights organisations in Belfast. And they have extensive experience of individual women and girls who've been through this situation. The first is Dawn Purvis, Core Volume 2, page 407, MS 9183. Ms. Purvis works for Mary Stopes International, which is a reproductive rights organisation working inter alia in Northern Ireland. And she sets out a number of anonymised clients who she's dealt with in recent years. Paragraph 8, MS 9183. Client B presented at MSNI, Mary Stopes, after she'd been raped by her partner with whom she was enduring a domestically violent relationship. She had children and was already fearful for them and didn't want any more. However, her partner refused to allow her to use any form of contraception. She'd sought assistance from her GP, but he'd refused to refer her to any healthcare provider for further assessment or assistance, telling her abortion was illegal in Northern Ireland. Mary Stopes assessed her as not falling within the grounds on which abortion is lawful in Northern Ireland. Client B was upset and distressed when informed she'd have to travel to England to access abortion services. Her distress was compounded by the fear of a controlling partner and the potentially violent reaction if he found out that she was pregnant and planning a termination. Client B travelled outside of Northern Ireland, where she underwent a termination of pregnancy procedure. Incest, next paragraph, client C, a minor under the age of 13, presented at Mary Stopes with a relative having become pregnant as a result of familial sexual abuse elsewhere within the family. Client C disclosed the pregnancy to the relative, but not the abuse. The relative, with client C's consent, booked an appointment. As is common in sexual abuse cases, client C had concealed the abuse and the pregnancy and was beyond 9 weeks and 4 days when she finally did disclose it. The critical point about 9 weeks and 4 days is that is the point where you can no longer take the early medical abortion pill, which of course would be is unlawful in Northern Ireland in any event, and I'll come to that in a few minutes, but that's why there's that reference there. Mary Stopes provide medical abortions only within the above time limit and not to girls under the age of 16. In this case, Mary Stokes initiated its safeguarding procedures, social services and the police became involved. Client C and her relative thought she could be treated in Northern Ireland. She had not travelled out of the country before and was frightened and distressed when told that due to her later gestation, it was necessary for her to travel to England. Mary Stokes supported client C, travelled outside Northern Ireland accompanied by a relative where she underwent a termination of pregnancy procedure. The police in this case requested that the products of conception be retained for evidence in the event of any criminal proceedings. Mary Stokes have procedures in place for such requests, and the police travelled to England to seize the products of conception. For those who are struggling to understand the euphemisms, that's the fetus. The other witness statement is from Mara Clark, same bundle, a few pages further on. Ms. Clark works for the Abortion Support Network, and she just highlight 3 cases that she refers to. Case 3, paragraph 12. Abortion Support Network was contacted by a 17-year-old girl who'd become pregnant as a result of rape and intimated that the perpetrator was a family member. She told ASN that she was afraid for her life if the family discovered she was pregnant. She was a member of the traveller community and told me, I'm a gypsy girl and we're not supposed to have intercourse before we get married. If they find out, they will actually kill me. I'm not kidding. ASN urged the woman to contact the Family Planning Association for counselling and advice, but she was afraid someone would see her. Pregnancy was already starting to show. She was terrified people would find out and either beat her or kill her. Unfortunately, we lost contact with her. She left several frantic messages quite late at night. We were never to get through on her number again. And then case 4, ASN was contacted by a support worker on behalf of a woman who'd been traumatised. She'd been raped and beaten by a group of men that included a close male relative, and it was some time before she realised she was pregnant, at which point her trauma was compounded by the fact that she couldn't obtain an abortion in Northern Ireland. I'm aware that a number of organisations and agencies in Northern Ireland had knowledge of this woman's circumstances, but no provision was made for her or assistance offered to obtain an abortion. And ASN managed to help her to travel to England. And then there's quite a moving piece about how grateful she was. The particular point to highlight in respect of those cases is that it may seem very easy to the court for a woman to just jump on a plane and come to England. But first of all, there's the trauma of being away from your support network. But as is also clear, in many of these cases, the women and girls in question are within a tight-knit community where going to England and therefore raising questions as to what has happened may be very, very difficult for them. And what that evidence shows is that the moment that women and girls most need the state to help them, when they've been raped or been subject to incest, particularly where they can't turn to family support, the Northern Irish state makes the girl either travel to England or Wales or wherever, or guilty of a serious criminal offence if she takes the early medical abortion pill. And in that respect, I leave to Miss Quinlivan to go through the facts of JR 76. But JR 76 was an under 16-year-old girl, got pregnant, took the early medical abortion pill with the help of her mother, and the mother ends up being prosecuted by the Northern Irish prosecutor. In terms of the impact on children, just finally in the evidence, it's important to understand how much of this does indeed impact on children. Core Volume 2, this time, page 288, MS 9062. This is statistical data produced by the Northern Irish government in its consultation paper on amending the law, produced by the Department of Justice.
Sorry, Ms. Leaven, page one.
I'm so sorry, page 288 in Core Volume 2,
Thank you.
9062 on the MS. And if the court could go to page 293 in this document, MS 9067, there's a table there, table 1, of illustrated recorded sexual crime 2010 through 2014 in Northern Ireland. And what is truly shocking about these figures is the number that seem to concern girls under the age of 18, under the age of 16. Sexual assault on female 13 and over, one can see the numbers. Sexual assault on female under 13, one can see the numbers. Sexual activity involving child under 13, that line slightly mystifies me because presumably the distinction sought to be drawn is between consensual sex under 16 and non-consensual. But the law is clear, you can't consent under 13. So I don't know why the Northern Irish authorities have done that line, but it doesn't really matter for my purposes. Sexual activity, child under 16, again, the court can see the numbers. But this is summarised if you go to the table opposite, on the opposite page, 294, victim age profile, reported sexual offences, 2012-13, under 18, 56%. So the majority of victims of reported sexual offences in Northern Ireland are under 18. Of course, that doesn't mean all of those people got pregnant. But it gives some indication of the impact on children of this law. So those are the facts for the present purposes. Can I then turn to a quick summary of the criminal law in Northern Ireland? And I should have said at the outset, wherever possible, I'm going to refer to our written case to speed things along. So if I can ask the court to take up our written case, which is in Core Volume 1, MS 8507. And the statutory provisions in play here are set out at paragraph 11 through 13, MS 8511, page 5. And I'm not going to read them through. I'm sure the court is fully aware of the import of the law. The fundamental position is that any woman who tries to induce a miscarriage in Northern Ireland is liable to life imprisonment. The terms of Section 58 and 59 of the 1861 Act were considered in England, because of the 1861 Act, these provisions applied before the 1967 Abortion Act, in the case of Bourne. And just if I can ask the court to take up Bourne, which is in Authorities Bundle 2, tab 10, MS 703. Bourne concerned, as you can see from the head note, a 15-year-old girl pregnant as a result of rape. And what Mr. Justice McNaughton found in Bourne was that the word unlawfully in the 1861 Act, you can see it at the top of page 3, MS 705, no person ought to be convicted under Section 58 unless the jury is satisfied the act was not done in good faith for the purpose only of preserving the life of the mother. And then what Mr. Justice McNaughton found...
That's by putting together the 1861 Act and the Infant Life Preservation Act.
Well, my lady, yes, but I think what Mr. Justice McNaughton was finding was that the Infant Life Preservation Act merely reflected the previous common law interpretation of the 1861 Act. I had thought that it was as a consequence of the Infant Life Preservation Act, but I think if you read the judgment, that isn't quite right, because he says he quotes at the top of the page the Infant Life Preservation Act, and then he says those words express what, in my view, has always been the law with regard to the procuring of an abortion. And then, my ladies, my lords, page 4, middle of the page, unfortunately this is in the days of no paragraph numbers, of course, middle of the page, I think second full paragraph, where it does not permit of the termination of pregnancy except for the purpose of preserving the life of the mother. As I've said, I think that those words ought to be construed in a reasonable sense. And if the doctor is of opinion, on reasonable grounds and with adequate knowledge, that the probable consequence of the continuance of the pregnancy will be to make the woman a physical or mental wreck, the jury are quite entitled to take the view that the doctor, who in those circumstances, in that honest belief, is operating for purpose of preserving the life of the woman. So that's where the test of physical and mental wreck comes from. And then that was further considered in the Family Planning Association case in 2005, which is in Authorities Bundle 1, MS 18. Sorry, Authorities Bundle 1, Tab 1. This is the case where the Family Planning Association brought a judicial review to force the Minister for Health to produce guidance on when abortion in Northern Ireland would be lawful. And at paragraph 122, you get the same point earlier, but this is the clearest encapsulation of it in the judgment of Lord Justice Campbell, reflecting what Lord Justice Nicholson said as well. Paragraph 122, MS 83. Effectively, it was the following formulation was agreed as to when termination would be lawful in Northern Ireland. It was in these terms: operations in Northern Ireland for the termination of pregnancies are unlawful unless performed in good faith for the purpose of preserving the life of the mother. The life of the mother in this context has been interpreted by the courts including her physical and mental health. A termination will therefore be lawful where the continuation of her pregnancy threatens the life of the mother or would adversely affect her mental or physical health. D, the adverse effect on her mental or physical health must be a real and serious one and must also be permanent or long-term. E, in most cases, the risk of the adverse effect occurring would need to be a probability, but a possibility might be regarded as sufficient if the imminent death of the mother was the potentially adverse effect. It will always be a question of fact and degree whether the perceived effect of a non-termination is sufficiently grave to warrant terminating the pregnancy in a particular case. So that is the law, but what I would like to do next is turn to the guidance that was eventually produced after the FPA case. I say eventually with loaded terms because the guidance wasn't produced until 2013. The guidance can be found at Core Volume 2, page 160, MS 8934. And this guidance is critical because this is the real world that Northern Irish obstetricians and gynecologists are working in, not the legal theory of the Supreme Court.
Right, give me the page.
I'm so sorry, my lord. Page 163 in CV2, core volume 2.
Right.
So I just want to read a few passages from this. 1.1, the aim of the health and social care system must be the protection of both the life of the mother and her unborn child. The objective of interventions administered to a pregnant woman must be to save the mother's life or protect against real and serious long-term or permanent injury to her health. Intervention cannot have as its direct purpose the ending of the life of the unborn child. 1.3. The circumstances where a termination of pregnancy is lawful in Northern Ireland are highly exceptional. This document is intended to guide clinicians on the application of the very strict and narrow criteria that are consistent with the law. It details the very limited circumstances under which a termination of pregnancy may be lawful in Northern Ireland. Examples of good clinical practice are provided throughout. Then 2.8, MS 8941. It will always be a question of fact whether the perceived effect of non-termination is sufficiently grave to warrant terminating the pregnancy in a particular case. In certain circumstances, the possibility of an adverse effect may be sufficient grounds if, for example, the imminent death of a woman was the potential adverse effect. In most other cases, the risk of the adverse effect would need to be more likely than not. And I would ask the court to note that, because when I come back to Article 3, and the cases like the refoulement cases, like Chahal and Sadi, one will see that the test given for the impact on women in Northern Irish abortion law is much higher than the normal test for an Article 3 breach. And I'll come back to that. But the test being put forward in this guidance is that the risk of the adverse effect would need to be more likely than not. And I then asked the court to recall the evidence of Miss Topley and what was said to her, the difficulty for a psychiatrist in saying that there will be a long-term or permanent impact on a woman's mental health in these circumstances on the basis of the psychiatrist having to think that adverse effect is more likely than not.
Well, you're conflating two different things, aren't you, there? And it may be that this is a problem in the terminology all the same, but all it actually says is that you must establish that it's more likely than not that there's a risk, not that you must establish it's more likely than not that the adverse effect to which the risk relates will come to pass.
Yes, my lord, that's right.
And one questions whether in human rights terms one isn't, when one talks about a risk of ill treatment, always saying that the risk must be more likely than not, because otherwise it doesn't exist. It might be said. But the actual effect mustn't be more likely than not, because that's a different thing. You're not talking of risk then, you're talking of the actual effect.
But we'll come to the case law in a bit, my lord, but I'm not entirely sure I agree with your lordship, because the approach is, in the human rights cases, to look at the very likelihood of the risk, not the likelihood of the effect, but the likelihood.
Well, that's what I'm putting to you.
Yeah.
That's all this is actually saying.
Well, absolutely, my lord, but even when one is assessing, by definition, if you're doing a prejudgment of, you can only do risk. You have to, that's the nature of the exercise. But the test being posited here, in my submission, is a high one. And one has to remember the context of this advice, which is if the doctor gets it wrong, they are at risk of criminal prosecution and ultimately life imprisonment. And then that is picked up, my ladies, my lords, at 213. It's important for practitioners to appreciate that anyone who unlawfully performs a termination of pregnancy is liable to criminal prosecution with a maximum penalty of life imprisonment. So this isn't me, contrary to what the attorney would have you believe, this isn't me threatening something that might never happen. This is the Department of Health, no, I get it wrong, the Department of Justice advising practitioners to be well aware of this risk.
I think it is the Department of Health.
It's health.
It is the Department of Health, sorry, I've got it wrong. maximum penalty of life imprisonment, a person who is a secondary party to the commission of such an offence is liable on conviction to the same penalty. And then 3.6, a couple of pages further on, 8944, the issue of potential long-term serious mental health impact as a result of the continuation of a pregnancy will require very careful consideration. It is expected that cases with a prognosis leading to a termination of pregnancy will be very rare. So perhaps it's unsurprising in the light of that guidance how very reluctant the consultants that we've seen reference to in the factual material were to not only not give an abortion, but not give any advice. So that's the law and the guidance. Can I then turn to the evidence on the international consensus on permitting abortion in these circumstances? If I can ask the court to take up again Core Volume 2, witness statement of Mr. Allenby, who's the Chief Commissioner. So it's Core Volume 2, page 154, MS 8928. So this is a passage, Mr. Allenby deals with a number of issues. One of them, at paragraph 46, is the degree of consensus within the Council of Europe, and there's more detailed evidence on this as well. So paragraph 46 gives you the MS 8928 gives the headline. In the 47 member states of the Council of Europe, other than in Northern Ireland, only 6 do not permit termination of pregnancy on grounds of rape, incest and fetal abnormality. Most countries allow for termination of pregnancy on request up to 12 weeks, with termination of pregnancy being allowed after this under certain circumstances, most usually regarding risk to the woman's life or health, fetal abnormality, or related to the circumstances of conception, for example, rape or incest. And then we get the detail of that at page 422 in the same bundle, MS 9196. This is an exhibit to Mr.
Page.
422, my lord, sorry. It's an exhibit to Mr. Allenby's witness statement that for some reason got separated in the bundles. And what he does here is, first of all, set out a summary of the situation across the Council of Europe member states, and then there's an appendix with the detail. But what I'd just like to pull out of the summary, first of all, is 2 points relating to the position in Germany and Denmark. Because if you go over the page to 423, in Germany, there is specific provision for a ground for abortion on the grounds of rape. You can see that in A(2). And I want to highlight this because one of the points that's constantly made against us is that both in terms of rape and incest and serious fatal abnormality, the categories are too vague, they're difficult to establish, and in practice, logistically, it's not possible to make provision. What one can see is that in Germany, Denmark, and indeed many other countries, there is specific provision, and those problems are overcome within the statutory criminal codes. So in Germany, at A(2), since termination of pregnancy is lawful in any event up to 12 weeks, there's a 3-day waiting period. In practice, those women who don't wish to disclose they've been raped will avail of the general access ground. Those women who wish to rely on the ground of rape do not have to wait 3 days or obtain a certificate of counselling. In those cases, the woman is not required to report the rape to the police. It's her doctor who issues the approval for the termination, but this doctor must be independent and must not be the same doctor who carries out the procedure. In Denmark, the next heading, slightly different, because Denmark B Roman 2, there the authorisation on the grounds of the authorisation is given by the medical committee, by the committee of the hospital where the termination of pregnancy procedure will be carried out. In Greece, C Roman 2, there's a ground for rape, but there's no requirement to report the crime to the police. In Poland, if the court goes over the page, which is quite relevant to this case because there are two cases in the European Court from Poland, E1, a termination of pregnancy is permissible where the pregnancy is a result of a criminal act and a prosecutor has provided a certificate. To obtain a certificate, the pregnant woman must report the rape to the police, who will instruct a prosecutor, and together they'll investigate the woman's complaint. The investigation includes medical examination of the woman to confirm the pregnancy, gather evidence for the criminal investigation. Alleged rapist is interviewed, and on the basis of all the evidence, the prosecutor will provide a certificate if she decides it's probable the pregnancy is a result of rape. So the point of showing the court that is just to show that there are solutions to the problem, different solutions in different countries, but solutions are perfectly possible. And then if we go to the appendix, what the court will see from the appendix, I'll take a few examples. If you go to 9201, Belgium, Bosnia, Bulgaria, Croatia, Czech Republic, Denmark, they all have provision for serious fetal abnormalities. They use slightly different terminology, and doubtless the clinical judgments would be slightly different. But what one can see, and you go on France, particularly serious, fetuses suffer, unborn child is suffering from particularly serious disease recognised as incurable at diagnosis. And one can pick up similar but slightly different tests in a very large proportion of the Council of Europe states. So again, the point to get out of that is that it is perfectly possible and workable to have a definition of serious fetal abnormality and to have a clinical judgment about that.
Are you right about, I'm just looking at Germany again,
Germany, my lord, I think, has special provision for rape.
yes it does, and
I'm not sure it has special provision for
yes, but your heading seems to be wrong, doesn't it, when it says on MS 9205 in the bold type, specific legal provision for serious malformation. That's not right, is it?
Well, my lord, I think the critical word might be or. This is intended to capture either situation.
No, but it isn't. If you read the text, it has a born test, and then it has a specific provision for rape or sexual crime. It doesn't have a specific provision for malformation of the fetus.
No, I'm sorry, my lord, I was being mildly facetious. I do apologise. The way this appendix has been drawn up is that the box is intended to cover either provision for serious fetal abnormality
Oh, I see.
or for sexual crime.
I see. No, I misunderstood you.
I'm so sorry.
And no, I understand, but it seems to me slightly misleading to include this in the list of cases which I thought you were referring to as providing for malformation.
No, my lord.
This is one of the exceptions.
What this appendix does is two things. It shows provision for serious malformation, and it also shows provision for sexual crime. I am reasonably confident that there must be some provision for malformation in Germany because of the 20-week issue. But your lordship is absolutely right, it isn't picked up in this table.
It certainly isn't in section 218.
No, we'll try and check that overnight, my lord.
Miss Leven, I wonder whether you're right completely to brush under the carpet the difficulty of deciding whether there's been a rape or an incident of incest. I mean, we know from all the criminal cases we have that after all the evidence is assembled and picked over before a jury, it's frightfully difficult to decide whether there's been a rape or an incident of incest.
My lord, I'm not trying to brush it under the carpet at all. What I am trying to show is that there are solutions. Even in Poland, there's a solution. It is impossible, I would suggest, to devise a system by which one can have a criminal trial before
Well, of
a
course.
woman or girl can have an abortion.
Of course.
So in order to allow for that category, effectively there are two ways to go. One is the Polish way of saying the prosecutor has to be satisfied, but plainly well below the criminal standard. Wouldn't be, your lordship's absolutely right, wouldn't be possible to have it at the criminal standard. Or alternatively, the German or Danish way to go, which is leave it for the clinician to decide. But I don't show your lordships and your ladyships this to say it's all completely easy. It's not, obviously not. What I show your lordships and your ladyships this for is to make the point that it is doable. Other countries do it. The suggestion that this is an impossible test and it can't be met is simply not borne out. And indeed, when one comes to the case of RR, I think I've got them the right way round, which is the Polish rape case, the system didn't work, well, as was clear from the Strasbourg judgment, because many of the authorities in Poland didn't really want it to work, but that there was a well-worked-out, detailed system for checking whether or not the prosecutor thought the woman was telling the truth is there. It's in the evidence in detail. But no, I'm not suggesting it's easy, but I am suggesting that it's doable. There is also the rather simple point that when you are talking about pregnancy for a girl under 16, a criminal offence has been committed. That is unarguable. The nature of the criminal offence differs, of course, to do with the girl's age and the issue of consent, but that a criminal offence has been committed is clear. Just finally, in terms of the international consensus, it is worth noting, as Mr. Justice Horner did, I can never get the list right, but as far as the 6 Council of Europe states are concerned who don't make provision for abortion in these circumstances, they are, as Mr. Justice Horner described, well, they're the Republic of Ireland, Northern Ireland, and a number of what he called micro-states, Andorra, San Marino, Liechtenstein, very, very small states where one can only assume, possibly with the exception of Malta, that it's relatively easy for the women and girls to travel. So that's the position on international consensus, and I'll come back to that when I come to the submissions on Article 8. Can I then move to the position in international law? Now, so far as the international law material is concerned, I'm going to leave the detail of that to be dealt with by Ms Gallagher, Queen's Counsel, on behalf of the Humanists, and Ms Mountfield on behalf of the UN Working Group. All I'm going to do is give the court the headline points and leave them to show the court the detail. If I can ask your ladyships, your lordship, to take up our case, see Core Volume 1, MS 8555, paragraph 136.
Sorry.
Core Volume 1, the case, my lord.
Yes.
Paragraph 136, just because this summarises the position. In this case, 3 of the treaty body committees have made concluding observations specifically in respect of Northern Irish abortion law and specifically in respect of the 3 categories, and said that Northern Irish the law we have an issue before the court today is in breach of their conventions. So we have the Committee of the Convention for the Elimination of Discrimination Against Women, the CEDAW Committee, made concluding observations in 2013 to that effect, the Human Rights Committee in 2015, and the Committee on Economic, Social and Cultural Rights in 2016. All 3 bodies have called on the signatory state, i.e. the United Kingdom, to amend Northern Irish criminal law on abortion in respect of rape, incest, and either serious or fatal fetal abnormality. And as I say, I'll leave the interveners to show the court the detail of that. Further, the Human Rights Committee, in 2 cases concerning Irish women with fatal fetal abnormality, Republic of Irish women rather than Northern Irish women, the 2 cases are Mellett and Whelan, the Human Rights Committee have found breaches of Article 7 of the International Covenant on Civil and Political Rights, which is equivalent to Article 3.
Can you just give us the references to Mellett and
Yes. I'm going to come to them later, my lord.
Well, they're your footnotes 236 and 237, aren't
It's
they?
in tab 27 of...
here we are. Yes, no, my
The
lord.
problem is, my lord Wilson, I don't know the bundle off the top of my head.
It's tab 144.
Yes, we've got
Volume
it there.
4.
No, that's very helpful.
Volume
Thank you.
4. And I'm going to come back to some of what was said in Mellett when I come to the discrimination ground. So what we have there is extremely specific international material. And I'll come back to that when I come to Lord Wilson's judgment in A and B. So then staying on international law, but the approach rather than the substance, and I think I can speed this along by referring to our case. If I can ask the court to turn to our case, MS 8524, paragraph 52 onwards, we set out there the principles of the approach of the Strasbourg Court, first of all, to the interpretation of convention rights in the light of international law. Members of the court will be extremely conscious, and I don't need to stress, that Strasbourg routinely, where a case is touched upon by international law, routinely refers to that law in interpreting the convention. And the principles set out in the case of Newlinger, which we refer to at paragraph 52, is that the Strasbourg approach is to interpret convention rights in harmony, those are the words used, with international law. Further, and more specifically, Strasbourg has relied on the international treaties in issue in this case in numerous cases, and we refer to many of them in paragraph 54 of the case. Operas and Turkey, the domestic violence case concerning Turkey, is perhaps one of the clearest and strongest examples. The attorney in this case sought to argue that the court should place less reliance on the views of the treaty bodies. So as I understand his case, it's okay to look at the treaty, but don't place too much reliance on the view of the treaty bodies. 2 points on that. 3 points, actually. First of all, Strasbourg, as the court will be aware, has often placed significant reliance on the views of those treaty bodies. Not just the treaties themselves, but the treaty bodies. Secondly, as I'll show the court when we come to them, the UN Human Rights Committee is the body that decided Mellett and Whelan is made up of very eminent jurists. The one that the court, many members of the court may be most conscious of, is the late Sir Nigel Rodley, who was in those cases, but also people like Professor Sarah Cleveland, Professor of Law at Columbia University. So
there's an overlap also with the European Court of Human Rights.
Indeed, my lord. So the idea that one can dismiss these bodies with the wave of a hand and say that little weight should be given to their views of their treaties, in my submission, is wrong. And that's dealt with briefly by Lord Carnworth in SG, which is Authorities Volume 2, tab 11, MS 742. This is the case, I'm sure the court is conscious of it, sometimes called SG, sometimes called JS, terribly confusing. Same case. Paragraph...
Benefit cap.
Benefit cap. Yes, but there are many of those by now. Benefit cap 1. Lord Carnworth at page 1482, paragraph 105, MS 742, one doesn't need to worry about the substantive detail, but what he said there was the comments in this court in HH predated and therefore did not take account of the most authoritative guidance now available on the effect of Article 3.1. This is in general comment number 14, adopted by the United Nations Committee on the Rights of the Child. And in my submission, what Lord Carnwath said there was entirely wrong.
742.
I'm sorry. The most
105.
authoritative guidance. 742, my Lord, paragraph 105. Now, the respondents in this case place great reliance on what my Lord Wilson said in A and B. And if I can ask the court to take that up. Authorities, Volume 1, Tab 5. I don't need to explain anything about this case to 4 of this court, but this was the case about where the argument was that Northern Irish women were being discriminated against for being charged for abortions in England.
Have you got an MS page?
Oh, I'm so sorry, MS 281.
281, thank you.
And the passage that my learned friends rely on is in the judgment of Lord Wilson at paragraph 35. MS 294. That paragraph 34, reliance was placed by the claimants on some of the conventions that are in issue here and some statements by the CEDAW committee. And then what your lordship said at paragraph 35, these 3 quotations represent the high point of the mass of such material now pressed upon the court. The conventions and the covenant to which the UK as a party carefully stop short of calling upon national authorities to make abortion services generally available. Some of the committees go further down their path. But as a matter of international law, the authority of their recommendation is slight, see Jones and Saudi Arabia. At its highest, one can say only that there's a trend in some of the international material to which the current law in Northern Ireland runs counter. The trend adds background colour to the inquiry into fair balance under the Convention. In my view, however, the claimants need material of a far more vivid hue to put into the balance against the Secretary of State's resolve to stay loyal to the overall scheme for separate provision of free health services within each of our 4 countries and to the democratic decision reached in Northern Ireland in relation to abortion services. Now, in my submission, that passage entirely helps our case and not the respondents. It is, in my submission, very difficult to envisage a case where there is more direct and compelling international material in support of one side's argument than this one. If you want vivid hue, this is starkly fluorescent. There are 3 sets of concluding observations directly on point on the very statutory provisions before the court, and there are 2 decisions of the UN Human Rights Committee directly on the same point. You could not get more direct international law. It's usually the case, in my experience in my submission, that international law has rather general words, and the argument is the degree to which they're on point. Here, in stark contrast, there is the absolutely specific views of the relevant bodies on precisely the issue that this court has to determine. And in my submission, it is important to note that so far as we have been able to find, and the respondents have found no different, there is no case in Strasbourg or the domestic courts where the court has flown in the face of the international law material in the way that would be necessary here to find for the respondent. No case. The respondents, the highest the respondents can put it, is they rely on ABC, the Strasbourg case on abortion in the Republic. And they say, well, the material here is not very different from ABC, international material. I'll have to come to ABC in a lot of detail when we get to Article 8. But just to rebut this point, can I ask the court to take up ABC, which is tab 3, Authorities Bundle 3, tab 13. And you can see the international material that was put before the Strasbourg Court at paragraph 109, MS 847. And I'm not going to read it through, paragraphs 4, 5 and 6, but one can see very easily that that material, although generally supportive of ABC's case, there's no doubt about that, is not in any sense comparable to the specificity of the material in this case, nor was there anything comparable to the findings of the UN Human Rights Committee in the Whelan and Mellett case. So to say that this court should dismiss the international material on the grounds that it was similar to or analogous to that was produced in ABC is, in my submission, simply wrong. Can I then turn to my next topic, which is Article 3? And again, we can probably speed matters along by having our case to hand. Of course, Article 3 is the prohibition on inhuman or degrading treatment. And the first point to make, which all members of the court, I'm sure, will be very familiar with, is that this is an unqualified right. Nothing can be put in the balance. And if I can ask the court to take up our case, paragraph 62, MS 8527. We set out their references to some of the relevant case law. The court, I'm sure, will be familiar with the Ireland and the UK case and the principle that even where there is a threat to the life of the nation, that would not justify a breach of Article 3. Perhaps more directly on point here is the case of Gefgen, which is just worth taking up for the starkness of its facts. Authorities Bundle 3, tab 15, MS 996. Gefgen is, I think it would be fair to say, a startling case on its facts. What it concerned was Mr. Gefgen had abducted a child, and it turned out he'd murdered him. But he served a ransom notice on the family, ransom demand, and the German police found him. And he was arrested, and at that stage, the German police thought the child was still alive. And they threatened him. They only threatened him. They didn't actually do anything, but they threatened him with severe physical abuse, torture, effectively. And the court was, and some time later, Mr. Gefgen complained of a breach of Article 3. So this was a situation where there was a live child, as far as the German police were concerned, and they thought that by threatening Mr. Gefgen, they might be able to save that child's life. So you couldn't get a starker situation. But the Strasbourg court found a breach of Article 3. And at paragraph 87, MS 996, they say, the court reiterates that Article 3 of the Convention enshrines one of the most fundamental values of the democratic societies. Unlike most of the substantive clauses of the Convention, Article 3 makes no provision for exceptions and no derogation from its permissible under Article 15.2, even in the event of a public emergency threatening the life of the nation. The court has confirmed that even in the most difficult circumstances, such as the fight against terrorism and organised crime, the Convention prohibits in absolute terms torture and inhuman or degrading treatment or punishment, irrespective of the conduct of the person concerned. The nature of the offence allegedly committed by the applicant is therefore irrelevant for the purposes of Article 3. So it couldn't be in stronger terms. Next issue under Article 3 is what's the standard that should be applied. And we know from the citation of in Ireland and the UK in our case at paragraph 62 that the court says it all depends on the circumstances of the case, such as the nature, context of the treatment, manner and method of its execution, its duration, its physical or mental effects, and in some cases the sex, age and state of health of the victim. In terms of the actual standard, it's useful to look at the case of Pretty, which is in volume 4, tab 21.
Can I just ask you, all these cases you're citing are cases where there was actually a particular victim of somebody claiming to be a victim of a violation of Article 3, and the court, as you've just read out, emphasises the importance of the circumstances of a particular case. And now, the sort of challenge you're bringing here doesn't really depend on the facts of any particular case, because I think you have to say that the law in question is itself incompatible with Article 3 rights.
My Lord, I'm going to come to that. This is a question of risk.
Okay.
Risk. That's why we've referred in our case to Chahal and Sadi, and why I'm going to show the court the case of Sufi and Elmi. Oh. Because what we're talking about here is the risk to the class of women and girls in question. But in order to determine what you've got to have a risk of, you've got to start with, the way I'm doing this, perhaps I should have done the signposts first, is what's the standard? Is there a defence? No. What's the standard? What's the approach to risk? And what are actually I've just put it in the wrong order, what are the factors with this class of people, i.e. women and girls pregnant by reason of rape, incest or with serious fetal abnormality, which make them particularly vulnerable? So if I have an absolute answer to your Lordship's point, but I'll come to it in a minute. So just staying on standard, Pretty, MS 1142, is of course the right to die case in the European Court. And at MS 1173, paragraph 49, the court turns to its assessment of the case under Article 3.
Sorry, paragraph?
Starts at paragraph 49, my Lord. But the passages I want to highlight start at 51. So at the beginning of 51, they refer to the obvious and oft-stated proposition that Article 3 requires states to take measures designed to ensure individuals within their jurisdiction are not subjected to torture or inhuman and degrading treatment or punishment, including such treatment administered by private individuals. A positive obligation on the state to provide protection against inhuman or degrading treatment has been found to arise in a number of cases. So there's no issue that Article 3 engages a positive as well as a negative obligation to the degree that it's useful to use that terminology. And then 52, as regards the types of treatment which fall within the scope of Article 3 of the Convention, the Court's case law refers to ill treatment that attains a minimum level of severity and involves actual bodily injury or intense physical or mental suffering, where treatment humiliates or debases an individual, showing a lack of respect for or diminishing his or her human dignity, or arouses feelings of fear, anguish or inferiority, capable of breaking an individual's moral and physical resistance. It may be characterised as degrading and also fall within the prohibition of Article 3. The suffering which flows from naturally occurring illness, physical or mental, may be covered by Article 3 where it is or risks being exacerbated by treatment, whether flowing from conditions of detention, expulsion, or other measures for which the authorities can be held responsible. So the fact that the authorities are not responsible for the fact the girl was raped, or that the woman has a serious fetal abnormality, does not take it outside Article 3. So, we've got a test of intense physical or mental suffering. And then there is a question of looking at the factors that are highlighted in Ireland and the UK as to whether the threshold in these cases should be a higher one or a lower one. And there are a number of points on this. The first is that the Strasbourg Court has said on a number of occasions that victims of rape are in a particularly vulnerable situation and that the state has a particular duty to protect them. And if I can take the court back to our case at paragraph 75, MS 8535, we set out there a summary of the case law in question. I'll come to the cases of RR and P&S at the end of the Article 3 analysis, so I'm not going to go to them right now, but P&S makes it clear that, again, that victims of rape are particularly vulnerable. But the case at paragraph 75, which we highlight, is MC Bulgaria, which is in Authorities Bundle 3, tab 17. I'm afraid, just give me a moment to find the MS reference. MS 1036. 14-year-old girl raped. And it would be fair to say treated pretty appallingly by the Bulgarian authorities. And what is said in that case at paragraph 150 this is in the context of both Articles 3 and 8, but specifically this paragraph refers to 8. Positive obligations on the state are inherent in the right to effective respect for private life. Obligations may involve the adoption of measures even in the sphere of relations between individuals. And then at the bottom of the paragraph, children and other vulnerable individuals in particular are entitled to effective protection. And then, sorry, I should have read the paragraph above. While the choice of the means to secure compliance with Article 8 in the sphere of protection against acts of individuals is in principle within the state's margin of appreciation, effective deterrence against grave acts such as rape, where fundamental values and essential aspects of private life are at stake, requires efficient criminal law provisions. Now, this case is about, MC Bulgaria was about criminal law protections, but I'm pointing to it here because it makes clear that a victim of rape is in a particularly vulnerable situation.
It was more about criminal law protections. There were two principal criticisms made of the Romanian authorities, one systemic and the other operational. The systemic deficiency was that resistance on the part of the victim had to be established in order to bring home a charge of rape. But I mean, your point is it doesn't matter what the deficiencies were. The recognition by the court of the vulnerability of those who have been subjected to sexual assault is a prominent feature of this area.
Absolutely, absolutely. The factual situation and indeed the legal remedy were different, but the analysis, which is that a victim of rape is particularly vulnerable and engages a positive obligation on the state to take positive actions, in MC Bulgaria, positive actions in terms of prosecution, in my submission, and this comes out of P&S, in the case of a woman or girl who's raped and is then pregnant, positive obligations in terms of helping her after the rape.
One can understand that, but how far does it go? Does the fact of rape mean that the existence of a potentially viable fetus is irrelevant?
The existence of a potential viable fetus is irrelevant under Article 3. That must follow from Gefgen.
Why does it follow from Gefgen?
Because the existence of a live child, a kicking, screaming 9-year-old, I think it was, or it might have been an 11-year-old, was irrelevant in Gefgen.
In other words, there's no counterweight.
There is,
when we're dealing with Article 3.
There is no counterweight. How could it be the case that you can't torture the man in Gefgen to save the child, which is what the German police thought they were doing, but you can inflict cruel, inhuman and degrading treatment on the woman and then find that's justifiable because there's a viable fetus? It doesn't work, my lords. But
I mean, Gefgen is a slightly different case because when in that situation, you can never be absolutely certain that what you're going to do is has a point. In fact, it didn't because the child was already dead, or that it will be effective. In the case of a woman who's pregnant, the potential infant is there, and to say that that's completely irrelevant in deciding what is inhuman or degrading treatment seems to me to go quite a long way.
well, my lord, in my submission, it sounds a stark submission, but it's right. It follows necessarily from the case law. Take one back to the terrorism cases. The defence the UK government was running in Ireland and the UK was that they had to inflict inhuman and degrading treatment on prisoners in Ireland because the very fabric of the state in Northern Ireland back in the late 1970s, I think that's when the case was at risk. That wasn't put in the balance. It's absolutely fundamental, and it's one of the points, my lord, where the law on abortion seems so out of sync with the law on the protection of other categories of people one might feel the court would have less sympathy with.
Sorry, say it again.
It's one of the areas, my lord, where the law on abortion seems seriously out of sync, because the assumption seems to be that when you have an article, just assume there is an Article 3 breach here, and we'll go through the steps in that in a moment. We're going through the steps on that, but assume there's an Article 3 breach. How can it possibly be the case that that can be justified or balanced by some putative right of the fetus when the court is so clear that if there is an Article 3 breach in terms of the risk to a convicted terrorist, convicted in case, I think in Sardi, but the mere risk means there's an Article 3 breach. Something's gone wrong there.
Do you accept that the existence of the fetus could potentially inform the question whether the threshold for Article 3 has been reached?
No, my lord, I don't.
I can quite understand your argument that once a breach of Article 3 has been established, then the existence of the fetus does not come into the reckoning because of the authority of these cases to the effect that an Article 3 breach is an unqualified, or at least the right to Article 3 is unqualified. But do you say that the existence of the fetus is left out of account altogether in making a judgment as to whether the threshold is reached?
My lord, I don't see, in my submission, it's very hard to see how it can be taken into account in the threshold, because inhuman and degrading treatment is inhuman and degrading treatment to the victim. The victim is the woman. If the woman with the severe fetal abnormality is forced to go through the pregnancy, why does the fact that there's a fetus change the impact on her?
It may be that the impact on the woman isn't the only relevant factor. I'm thinking of a different context, but it's gone through my mind that in the Thompson and Venables case, I don't know if we have that, but my recollection is that the court treated the absence of any intention to degrade or humiliate the boys on trial was a relevant factor in considering whether there had been a breach of Article 3.
Yes, my lord, that I accept. The case law, and we'll look at it in a moment, is clear that absence of intention doesn't mean there can't be a breach of Article 3. But I quite accept that intentionality may be material to whether there's a breach. The case, Mr. Blundell will check it, is that there's a passage that makes it entirely clear that, I think it's in RR, that absence of intention is not determinative, but that it may be a factor, yes. But that's very different from the suggestion that the fact that the woman is pregnant and therefore there is a fetus changes the threshold for Article 3. That, with respect, I find very difficult to see analytically how that can be correct. And that's where, in answer to my Lord Mance's question, in my submission there's a real inconsistency that's creeping into the case law here, or potentially creeping into the case law. Because if the real live child is irrelevant in Gefgen, then how can the fetus, whatever one thinks about its embryonic status, and I'll come to Article 2 later, how can the fact of a fetus change that approach? Is that intentionality? Yeah, I'll come to. Can I just return to the case on this point about vulnerability and the impact of rape? Our case, paragraph 77, we cite the case of Aidin. I'll give you the reference, but I don't think we need to turn it up. It's volume 11, tab 101. What the court said in Aidin, see it at paragraph 77 of the case, rape leaves deep psychological scars on the victim which do not respond to the passage of time as quickly as other forms of physical and mental violence. The applicant also experienced the acute physical pain of forced penetration, which must have left her feeling debased and violated both physically and emotionally. And, of course, not being suggested that the state has done the rape. That wasn't the point in Aidin either. It's the impact on the victim and why the victim is particularly vulnerable. Just in the light of the questions a moment ago, perhaps if I just ask the court to turn up RR, which is Authorities Volume 4. I'm going to have to come back to this case, but Authorities Volume 4, tab 22, MS 1185. Oh, this is the intentionality point. Paragraph 151. Just so that I can give my Lord Reid the reference.
Page reference.
Oh, I'm so sorry, MS 1218.
Thank you.
So, RR was a fetus with serious fetal abnormality. Paragraph 151, although, what starts 150, treatment has been considered degrading when it was such as to arouse in its victims feelings of fear, anguish and inferiority capable of humiliating and debasing them. Although the purpose of such treatment is a factor to be taken into account, in particular whether it was intended to humiliate or debase the victim, the absence of any such purpose does not inevitably lead to a finding that there had been no violation of Article 3. For example, the court has found violations of that provision in many cases where the authorities dealt with requests to provide information of crucial importance for the applicants, for example, about the whereabouts and fate of their missing relatives, disclosing a callous disregard for their vulnerability and distress.
But if the absence of intention is not completely irrelevant. One can postulate a country where the religious belief of the population and government leads to an almost complete ban on abortion. They wouldn't have, that government and legislature, any intention to torture, but they would have a belief in the sanctity of the fetus from conception. Wouldn't that be a relevant consideration? It might be completely outweighed by other factors, but I'm still having difficulty in seeing that you can, under Article 3, isolate the whole context from that consideration, or simply focus on one side of the effect. It appears you can't, because intention is not on the part of the victim, it's on the part of the inflictor.
My Lord, I think my answer to that would be that that belief might well go, as we see from ABC, to the lawfulness of the general law on abortion. That effectively was the ratio, as I'll show your lordships, of ABC. But if you take the case of rape, if the court concludes that there is a real risk that in the case of women and girls who have been raped, forcing them, not allowing them to have an abortion, and forcing them to either go through the pregnancy, act unlawfully, or travel to England, is cruel and inhuman treatment, then in my submission, even if that were reflective of the views of that society, that would not mean there was no breach of Article 3. That
No, I mean, one can see that argument, but it doesn't really answer the question which I was putting, which is whether, whether you don't nonetheless look at the whole picture. It maybe you come to a clear answer because of the seriousness of rape and because of the appalling implications of having to carry a child as the result of rape termination when you don't want to. But maybe the answer is simple, as you suggest.
Well,
to suggest you leave out of account the existence of a viable fetus completely is the point which is worrying me.
Well, I can see emotionally, morally, psychologically why one might be worried by it. But I would ask the court, would ask your lordship, to think about the comparison with Ireland and the UK. I think I may have misspoke when I said late 70s. I think it was early 70s, 73, 70. A time when it was... Northern Ireland, and Lord Kerr can speak to this far better than I, was descending into civil war, where it was seriously being suggested by the UK government, probably in retrospect wrongly, but seriously being suggested that the conditions of treatment of those prisoners was essential for the survival of the state. I mean, this is where, as I say, there is this real inconsistency, because it may feel, internally one may feel that that is different from abortion. But actually, rationally, if you can't inflict treatment of a certain type in order to keep your very state going, and a much more real risk, I would suggest, than in many of the more recent terrorist cases, and again, Lord Kerr will speak to this infinitely better than I. You can't take it into account then. Why can you take it into account in terms of the moral views of the population? It's a different dilemma, but and that's why the force of what the Strasbourg court said in Gefgen is so important.
Well, the premise of your submission in both contexts is that there has been a violation of Article 3. And the simple proposition you make is that once there is a breach of Article 3, there is no defence available. That's what it comes to.
Absolutely, absolutely. And
however much one may be engaged by the lack of consideration for the fetus in this particular circumstances, you say that that is the stark state of the law.
Absolutely, absolutely.
Ms. Leven, you've read out the Strasbourg court saying the purpose of such treatment is a factor to be taken into account. And at the moment, It seems to me that that sentence is contrary to your absolutist exclusion of the unborn fetus and the purpose of this treatment being to protect the unborn fetus.
Well, my Lord,
Are
can
you
I-
right to put it in such absolute terms?
I think I am, my Lord, because, well, what I need to do to answer your Lordship's question is come to treatment and look at what the treatment is here.
Very well.
Can I deal with your Lordship's point then?
Of course.
So, can we just
To
Oh, so sorry, Mary.
clarify, the 5 techniques were adopted in 1971. The case was in 1978.
Oh,
So we're both right.
well, we're both right. Good. Honours even, my Lord.
9th of August 1971.
Yeah. The case is at 4138. But you need to dig a little to get the dates.
Just, can I, sorry, I may have asked the court to put it away. Can I just ask the court to go back to RR Poland for a moment for the vulnerability point? So RR Poland was authorities for tab 22. And we were looking a moment ago at 151, but if I can ask the court to look at 159, MS 1220. The court notes that the applicant was in a situation of great vulnerability. So this was the severe fetal abnormality case. Like any other pregnant woman, she was in her situation, deeply distressed by information that the fetus could be affected with some malformation. Natural, she wanted to obtain as much information as possible, find out about the options, and then there's reference to her acute anguish through having to think about how she and her family would be able to ensure the child's welfare, happiness, and long-term care. And then the point I wanted to highlight is at 159, 4 lines from the bottom, no regard was had to the temporal aspect of the applicant's predicament. She obtained the results of the test when it was already too late for her to make an informed decision on whether to continue the pregnancy or have recourse to legal abortion, as the time limit provided had already expired. The court, and then 160, the court is further of the view that the applicant's suffering, both before the results of the test became known and after that date, could be said to have been aggravated by the fact that the diagnostic services which she'd requested early on were at all times available, and she was entitled as a matter of domestic law to avail herself of them. I'm going to come to this point later, but my learned friends the respondents seek to distinguish RR and P&S on the grounds that in Polish law there was an entitlement to an abortion, but effectively the Polish authorities made it impossible to happen. But I would ask the court to note that that was only an aggravating factor in 160.
One
So-
can see how, in relation to degrading treatment, an intention to degrade and to humiliate, which is known to the victim, would be a factor to be taken into account. The lack of an intention to humiliate and degrade is not determinative.
Absolutely,
That's
my
what
lady.
is being said.
Absolutely.
If you actually mean to humiliate and degrade somebody, well then obviously that is going to make what you do more likely to reach the required level of severity.
Yes.
If you don't, that factor isn't there to increase the severity. It doesn't necessarily mean that it stops it being humiliating.
Yes,
and degrading.
absolutely, my lady. And I think the clearest examples of that are cases like the case the Lord Chief Justice cited, Sluchaev, which is the one about the Russian police knocking the detainee's glasses off. Now, obviously, knocking somebody's glasses off per se is not Article 3 ill treatment. But in the circumstances where they detained him, and he was elderly and vulnerable, and they were plainly doing it for the purpose of humiliating him, presumably to break his resistance. I can't remember the facts sufficiently clearly as to why they were doing that. That may be relevant, as your ladyship says. The other example is a case I'm familiar with, Algerian suspected terrorists and whether they could be deported with assurances to Algeria. It came before this court, I think, under the name of RB. And the ill treatment there was targeted at humiliating them with the risk was, it was targeted at humiliating them with the intent of breaking their resistance and therefore potentially giving false confessions. So intent is relevant, as Your Ladyship says, as an aggravating factor or an additional factor, but the lack of intent, if one looks at the treatment in question, doesn't mean that it isn't Article 3. But I'll come to the treatment, I promise, in a moment. So just returning then to where we were, which is what are the factors here that make these victims particularly vulnerable and push the threshold of Article 3 severity down, not up. We've had the facts of being a victim of rape, being pregnant with a severe fetal abnormality. The next one is often age. We've seen the court's seen the statistics. Many of the victims of sexual violence, in fact, most of the victims of sexual violence in Northern Ireland are under 18. And the next factor in the list from Ireland and the UK is duration. Now, it's clear from cases such as Slusharov and indeed the Algerian refoulement cases that duration can be short, can be very short in the case of Slusharov. In these cases, the cases that your lordships and your ladyship need to be concerned about, the duration is never short, and indeed it can in some cases be a lifetime. Miss Topley was forced to remain pregnant with a fatal fetal abnormality for, I think we calculated it as 15 weeks post-diagnosis. So for those victims, those women and girls who get abortions, the duration of their trauma will be weeks, but how many will vary. For those women who don't get an abortion, they will be living with the consequences possibly for the rest of their lives. The facts on duration and impact of treatment by the state, in my submission, in the fetal abnormality cases, in the rape case, first of all, is almost identical to the facts of P&S, the Polish rape case. And P&S is at Authorities Bundle 3, tab 20, MS 1100. This is the 14-year-old girl who became pregnant after rape, who did eventually get an abortion, unlike the woman in RR, and one can see the conclusion of the court, paragraph 157, court's assessment under Article 3. The court found a breach of Article 3 in this case. You can see the alleged violation starts at 150. 157, the court refers to 1135 in the MS, ill treatment must attain a minimum level of severity. 160, sorry, 158. Treatment has been held by the court to be inhuman because inter alia it was premeditated, was applied for hours at a stretch, and caused either actual bodily injury or intense physical and mental suffering. So one can see duration can be very short. Treatment being considered degrading, such as to arouse in victims feel of fear and anguish. And then 160, purpose. Although the purpose of such treatment is a factor to be taken into account, in particular whether it was intended to humiliate or debase, the absence of any such purpose does not inevitably lead to a finding there will be no violation. Moreover, it cannot be excluded that acts or omissions on part of the authorities in the field of healthcare policy may, in certain circumstances, engage their responsibility under Article 3. For the court's assessment of this complaint, cardinal importance, the first applicant was at the material time only 14 years old. Certificate issued by the prosecutor confirmed her pregnancy had resulted from unlawful intercourse. That's the point, my Lord Wilson, I was going to come back to. You can see, if you read the facts of this case, you can see how the Polish system worked, or actually on the facts didn't work. Court cannot overlook the fact that the medical certificate issued immediately afterwards confirmed bruises on her body and concluded physical force had been used to overcome her resistance. In the light of the above, the court has no choice but to conclude that the first applicant was a situation of great vulnerability. And then it goes on to record the experience that she had, culminating in the fact that she did, in the end, get an abortion. And then at 166, on the whole, the court considers no proper regard was had to the first applicant's vulnerability and young age and her own views and feelings. So I haven't got time to go through the facts of this case in detail, but the court will see when it reads it at its leisure that in terms of duration of this girl's ordeal, it was similar, unsurprisingly, to the kind of evidence before the court here. And equally, and again, I'm not going to go back to it, RR, the case authorities 4/22, she was diagnosed with a severe fetal abnormality, not a fatal fetal abnormality, and she had to, in the end, carry through the pregnancy and gave birth. And what she went through was very similar in reality to what Ashley Topping went through. So just in terms of threshold, finally, for Article 3, before I come to treatment, the Lord Chief Justice, in his judgment at paragraph 61, MS 8799, suggested that there was a higher standard of severity under Article 3 for abortion cases than for other cases. 2 points on that. First of all, in my submission, that actually is not a correct analysis of the case law. The cases the facts of RR and PS do not suggest a higher standard. But if I'm wrong on that, and a higher standard has crept in, and that's where the Strasbourg case law has got to, in my submission, that's wholly unjustifiable. And this court should not accept that there is any higher standard that a woman has to cross, woman or girl has to cross in the circumstances of this case. So can I then turn, still under, of course, Article 3, to the issue of treatment? Now, the respondents say that there is no treatment by the state here, so Article 3 is not in issue, and it's the attorney's case, paragraph 34, MS 8681, and onwards. And then presumably they would go on to say, if there is any treatment, then it isn't deliberately inhuman or degrading. In my submission, neither of those propositions are correct. The treatment here can be characterised in a number of different ways. I think there are 3. The first is that the women and girls in these cases are subject to criminal sanction with penalty up to life imprisonment. That very criminalisation of women in the most vulnerable situation is ill treatment by the state. It's not equivalent to Pretty and that line of cases. This is equivalent to P and S. In Northern Ireland, if you're a 14-year-old girl and you're raped and you try to get an abortion, you're at serious risk of criminal prosecution. These victims of rape are women the state, we know from the case law, has positive obligations to protect. But instead, in Northern Ireland, the state says they are criminals if they seek an abortion. And can I just ask the court to bear very closely in mind that that is not an empty threat or a statute honoured in the breach. Ms. Quinlivan will explain to you the facts of JR 76, and that is not the only recent prosecution of women who have sought an abortion. So a girl of 15 in Northern Ireland, raped by a family member who takes an early medical abortion pill bought over the internet, is guilty of a serious criminal offence. In my submission, that is inhuman treatment. But secondly, quite apart from the fact of criminalisation, there's the impact of criminalisation. That 15-year-old girl who takes the early medical abortion pill and is deeply traumatised by the whole experience, she can't go to her GP, she can't go to CAMS, to the Child, Adolescent and Mental Health Services, she can't go to counselling, because if she does, she is at threat of criminal prosecution. See the facts of JR 76, not an empty threat. But even worse, and even more inhuman, is that that 15-year-old girl can't even ask her mother to help her get the abortion pill over the internet, because her mother will be at threat of criminal prosecution. In fact, the facts of JR 76 suggest that the prosecutors in Northern Ireland choose to prosecute the mother and not the girl. So you are the most vulnerable situation. You're a 14-year-old girl who's been raped by a family member, and if you know what's going on in Northern Ireland, you can't even ask your mum to help. That is cruel and inhuman. And then you can't take the early medical abortion pill because you're so scared of the consequences. You're forced to travel. So take the serious fetal abnormality cases, the Sarah Hewitts and the Ashley Toppings. You're forced to travel away from your support network. Maybe you're rich enough, and now in the light of Miss Creasy's wonderful intervention, the state will pay for your partner to go with you. But you're still having to travel away from your family, the doctors who've cared for you, who you may have a close therapeutic relationship with. You're home, and you're forced to travel to England or Wales or wherever, away from that support and away from those doctors. And in my submission, those women are being punished for the circumstances they find themselves in. And their terrible situation in each one of those circumstances, whether you're raped by a family member, raped by somebody else, or you've got a severe fetal abnormality, that terrible situation is being made much worse by the positive acts of the Northern Irish state. The idea that the women whose evidence we've seen is being given the best medical care in Northern Ireland is ridiculous. It's a fig leaf of respectability which the Northern Irish authorities should not be able to hide behind. How can it be said that Ashley Topping, let alone Denise Phelan, were getting the best medical care which forced them to remain pregnant with a fetus at risk of poisoning them? How can the 13-year-old rape victim be getting the best medical care for her mental health by being forced to either travel away from her family or risk criminal prosecution? And in my submission, all of those three things are treatment by the Northern Irish state. So then one comes to the analysis of risk. So what's the risk of that ill treatment? The respondents say, well, there can't be a breach of Article 3 because there has to be an individualised assessment. In my submission, this is an area where the submission is wrong and where the case law has introduced a strange and unjustified anomaly between different classes of Article 3 case. In the line of cases concerning returning convicted or suspected terrorists, or indeed simply failed asylum seekers to the country of origin, the question is whether they would be at risk of a breach of Article 3 if returned. Now, as everyone on this court will know, what the court does in that situation is assess the risk of that individual suffering inhuman and degrading treatment if returned. So it's a risk assessment. And it largely turns, actually, if one considers the cases, not on the evidence about individual risk, but on the risk of return in the country, whether it be Algeria, I've got a mental blank where Mr. Sardi was going back to, or Sufi and Elmi, Somalia, is the risk of return to that country for that class of person, i.e., for Mr. Sadi's case, a person suspected of terrorism. In Sufi and Elmi's case, merely people who are being returned after a time in Europe. And
Tunisia.
Sorry?
Tunisia.
Tunisia. I knew it was somewhere in North Africa, but it wasn't Morocco, but my mind went blank. The question is their exposure to the risk of Article 3 ill treatment. So, if one applies the same analysis here, what's the risk that a victim of rape who wants an abortion will suffer inhuman and degrading treatment if they're either forced to travel to England, forced to continue with the pregnancy against their will, or illegally take the early medical abortion pill and take the risk of criminal prosecution? Of course, not every woman or girl in that situation will suffer Article 3 ill treatment. The woman or girl in question may be, to put it colloquially, a tough cookie who shrugs her shoulders and gets on with it. But there has to be a very serious risk that she will be subject to intense mental suffering. My learned friends will say, well, Miss Leaven's picked all the hard cases. There's loads of women out there who shrug off being raped and having to travel to England away from their families, or who have a serious fetal abnormality but think little more of it. That, in my submission, is a travesty. We have picked, probably, some of the hardest cases, but if the court just stands back for a moment and thinks, what's the risk of inhuman and degrading treatment here? In my submission, the risk in each of those categories is very strong. And a critical point in this, in terms of that great Strasbourg line about convention rights being practical and real, not theoretical and illusory, is that unlike Mr. Sadi and Mr. Chahal, the women and girls in these cases don't have years to vindicate their rights. They can't go to Strasbourg and give the evidence of the risk. They have weeks, in cases of serious fetal abnormality, days sometimes, to make the decision on what to do. And it's no good for them, years later, persuading a court that on an individualised assessment they were highly vulnerable. That does them no good at all. The law has to be in place that allows them not to be placed at that risk. And the clearest case on the broad nature of the risk assessment is the case of Sufi and Elmi. So I'm just going to take the court to that. Now, that is Authorities Bundle 23, MS 8203. So it's tab 235. And I expect some of this court will be quite familiar with this case. It's the case about asylum seekers, failed asylum seekers, being returned to Somalia and Somaliland. And the issue was, or one of the issues was, whether they were at risk of Article 3 ill treatment. Now, there are two important points about this case. Obviously, I haven't got time to go through the facts in detail. But for those of the court who are not familiar with it, one is, unlike the Sadi and Chahal line of authorities, there was no suggestion that Sufi and Elmi would be subject to intentional ill treatment in the sense that they were not the target of any authority in Somalia or Somaliland. effectively, to put it colloquially, the risk was they'd simply be caught in the crossfire. Because these were states, I think Somalia in particular, where al-Shabaab was running riot, and they were placed at generalised Article 3 risk. So it's an interesting case about, there was intentional violence, but it wasn't in any sense targeted at the individuals, unlike Mr. Sadi and I think particularly Mr. Chahal, where one might say that I think the Indian authorities might have had a particular interest in it. But the other point is that the risk assessment was completely generalised. So if I ask the court to go to MS 8244, which is the court's assessment, the specific subheading is the security situation in Mogadishu, and paragraph 248, which is MS 8245, the court considers that the large quantity of objective information overwhelmingly indicates that the level of violence in Mogadishu is of sufficient intensity to pose a real risk of treatment reaching the Article 3 threshold to anyone in the capital. In reaching this conclusion, the courts had regard to the indiscriminate bombardments and military offensives carried out by all parties to the conflict, the unacceptable number of civilian casualties, the substantial number of persons displaced with and from the city, and the unpredictable and widespread nature of the conflict. So, two things from that passage. One can see that the risk, as I say, simply relates to being caught in the crossfire. No intentionality, no purpose of torture or inhuman or degrading treatment, as potentially in Sadi or Chahal. But also that the test there is simply real risk, which I think the court possibly doesn't have the Vilvaraja case where the test for risk is analysed. But real risk is, in my submission, not actually a desperately high test, and is certainly a lower test than that set out in the Northern Irish abortion guidance, which I referred the court to earlier. Your Lordships will remember the discussion I had with Lord Mance and the reference in the Northern Irish abortion law guidance to the risk would need to be more likely than not. So, in my submission, the question for this court on Article 3 is there a real risk that women in these three categories will suffer treatment which crosses the Article 3 threshold? And in the light of the evidence, in my submission, there is only one answer to that. So finally on Article 3, and I think I've done much of this already, I was going to take the court to the two Polish cases and ABC to see how the Strasbourg court has approached Article 3 breach in abortion situations. We've already looked at both RR and P&S. But can I just deal with the respondents' overarching submission on those cases? So what the respondents say in relation to those cases is that there was only a breach found by the court because in Polish law, both of those women a woman and girl, had a right to an abortion, but was denied the abortion in practice. So the respondent's position on those cases is there was only a breach of Article 3 because they were denied something that they were entitled to in domestic law. Now, 2 points on that. First of all, in my submission, that argument is wrong in principle, because what it does is reduce Article 3 to a remedy for domestic law breach, which simply can't be right. So what they're saying is, well, the focus is not on the fact of the impact on you of the ill treatment. The focus, you the woman, the focus is on the fact that you had domestic rights which were breached. But in any event, secondly, and in any event, in my submission, it's not right on the facts of those cases. If the court reads through the facts and the findings in those cases, what is clear is that it is the impact on the woman in RR and the girl in P&S of not being able to get the abortion. In P&S, the long period, and in R&R, the fact that she couldn't get it at all and she had to give birth to a fetus with serious fetal abnormality. So actually the respondent's analysis of those cases isn't right if you read the facts. It is right, as your ladyships and your lordships have already seen, that the court in those cases refers to the Polish law, but that's hardly surprising because that was the factual and legal backdrop to the cases. Doesn't mean that that was the ratio, it was only because of the Polish law that breaches were found. So in my submission, those cases are strongly, for the reasons we've already looked at some of the paragraphs, strongly in our favour. The third case that the respondents refer to on Article 3 is the ABC case. ABC, as I've already said, lies at the heart of the Article 8 case, and I'll come back to it in a moment. But the respondents place reliance on it because there was an Article 3 claim in ABC, but it was rejected by the court. Now, as I say, I'm going to look at ABC on Article 8 in some detail in a moment. But the important point about ABC for the purposes of Article 3 is that it did not concern women who were pregnant by reason of rape or incest or women with serious fetal abnormality. It says nothing about that issue for the purposes of Article 3, about this case for the purposes of Article 3. It is those factors, rape, incest and serious fetal abnormality, which in our submission create the breach of Article 3. So any woman in Northern Ireland who's pregnant and wants an abortion is in, as I think Lord Wilson said in A and B, a very unenviable situation. But rape, incest and serious fetal abnormality puts them into a different class for the purposes of Article 3. So in my submission, ABC will tell this court nothing about whether there's a breach of Article 3 here. So, can I move on to Article 8? Next topic. There is no issue that Article 8 is engaged. That's not being contested by the respondents, as I understand it. But rather than just taking that as a tick in the box, can I just make the submission?
So, sorry, when you say it's engaged, do you mean that there's no dispute that there is an interference with the Article 8.1 right?
Yes, absolutely, my lord. We're in the territory of 8.1. But in my submission, it goes further than that, because in doing the balancing exercise under Article 8, it is critical to take into account how serious the interference is. So there's a full weighting exercise going on here. And in my submission, the intrusion into a woman's personal autonomy by refusing her an abortion in these circumstances is an exceptionally serious interference in her Article 8 rights. What we're talking about here, my ladies, my lords, is the state exercising control over a woman's body in the most extreme circumstances. I'm going to say no more about that because Miss Rose, QC, on behalf of the Family Planning Association, is going to make submissions this afternoon on issues around personal autonomy. So, thinking about the balance, very weighty side on level of breach, Article 8.1. So, can I just go straight on into Article 8.2 and the alleged justification? So there are two questions the court has to address. Does that interference in the woman and girls' Article 8 rights A, pursue a legitimate aim, and B, is it necessary in a democratic society? And at this stage, I'd like to deal with the respondent's argument that the other side of the balance is the protection of the fetus and their reliance on the case of Vaux and France and their argument that Article 2 is in play. Now, Vaux is in Volume 4, tab 26, MS 1335. Volume 26, tab 26, not tab 24. And for these purposes, it might be useful for the court also to have our reply, which is at Core Volume 1, MS 8747. And the reply is at the back of the first core volume. And we deal, just so that the court can see the references, we deal with Article 2 at paragraph 13 onwards, MS 8. So going to Vaux, just worth noting what it's actually about. So MS 1335. Following medical negligence at the hands of a doctor, the applicant suffered injury to her amniotic sac, which in turn necessitated the termination of her pregnancy. The fetus, a baby girl, was between 20 and 24 weeks at termination. The doctor was charged with causing unintentional injury, but was acquitted on the grounds that the fetus was not, at that stage, a human person. The acquittal was ultimately upheld by the Court of Cassation. The applicant claimed that Article 2 had been violated and claimed just satisfaction. The government argued that the claim was not inadmissible. So the first point to note from the facts was that Vaux was not a case about reproductive rights, and it was not a case where the woman was asserting the breach of Article 2. It was not a case where there was any conflict between the woman's interests and the alleged interests or rights of the fetus. The woman, the pregnant woman, was asserting the breach of Article 2 on behalf of the fetus. So there was no Article 8.2 balance to be done in Vaux. It's just not about that issue at all. But the second point to make is what is striking in my submission about Vaux, and in particular striking about the respondent's reliance on it, is that Strasbourg didn't find that the fetus had any Article 2 rights. If the court goes to paragraph 76, from 76 onwards, the court considered the existing case law on fetal rights and Article 2. And it's necessary to read through from 76 all the way through to 80 and then onwards. But the core points to pick up are at paragraph 77, where there's reference to X and the UK and the Commission's consideration in that case. About halfway down the paragraph, the court says, the Commission added that the general usage of the term everyone, that's everyone in, for example, Article 6.1, and the context in which it was used in Article 2 of the Convention did not include the unborn. As to the term life, and in particular the beginning of life, the Commission noted a divergence of thinking on the question of where life begins, and added, while some believe that it starts already with conception, others tend to focus upon the moment of nidation, upon the point that the fetus becomes viable, or upon live birth. But the critical point in the middle of 77 is, at that stage, the stage of X in the UK, the Commission had perfectly clear everyone in Article 2 didn't include the unborn. But then if one goes on into 80, where the court reaches its position in the light of that case law. It follows from this recapitulation of the case law that in the circumstances examined by the Convention institutions, that is, in the various laws on abortion, the unborn child is not regarded as a person directly protected by Article 2 of the Convention, and if the unborn do have a right to life, it is implicitly limited by the mother's rights and interests. The Convention institutions have not, however, ruled out the possibility that in certain circumstances, safeguards may be extended to the unborn child. Nobody would dispute that. We've seen from Mr. Allenby's appendix that almost every state has some protection in its abortion law. That is what appears to have been contemplated by the Commission in considering that Article 8.1 cannot be interpreted as meaning that pregnancy and its termination are, as a principle, solely a matter of the private life of the mother, and by the court in the above-mentioned Bosso decision. It's also clear from an examination of these cases that the issue has always been determined by weighing up various and sometimes conflicting rights or freedoms claimed by a woman, a mother or a father, in relation to one another or vis-à-vis an unborn child. So what is absolutely clear from that paragraph is that Vaux did not find that the fetus or the unborn child was a person for the purposes of Article 2. Yes, it can have statutory protection. Yes, most Council of Europe members give the fetus some statutory protection. No, it doesn't have the protection of Article 2.
Doesn't the court go on to say in paragraph 82, in particular over the page, that that's a question within the margin of appreciation, and when the right to life begins is a matter for each court, for each state to determine for itself. If it
yes, absolutely, my lord, and I was about to come to that. That's at 82 over the page at 294.
So you might get you might get a state of the sort that I postulated earlier, where the view was taken that the fetus did have the rights of a person.
Yes, well, my lord, whether you could postulate the fetus had the rights of a person, you certainly could postulate certain protections for the fetus. But the point I'm making here is that the Strasbourg court has not given the fetus any Article 2 rights. So we can, as it were, cross the Strasbourg court off. It said margin of appreciation in the sense that, because we all know margin of appreciation can have two different meanings, in the sense that matter for the domestic courts. So the next stage is, well, what have the domestic courts done?
Well, matter for the domestic state, it is not just for the courts, it's a matter for the relevant state.
Yes.
And if the legislature of the relevant state attaches a different significance to an unborn child and goes further than Strasbourg would, you would accept that. Indeed, you endorse that as a possibility in other connections.
Yes, well, and perfectly obviously, my lord, the Northern Irish state here, or the Northern Irish Authority, has statutory protection. There's no issue about that. But in terms of the rights of the fetus, stage one is Strasbourg doesn't give them rights. Stage two, which I think I will come to after the luncheon adjournment, is that domestic law set out in cases like RMB, Payton, and Attorney General Reference 3 of 94, state in the clearest possible terms that the fetus is not a person and does not have autonomous rights. So the domestic courts, this statutory protection, no doubt about it, but in terms of fetal rights, the domestic courts in the UK, and there's no suggestion that the Northern Irish law is any different on this, have made the position absolutely clear. The fetus has no rights. It has statutory protection, but it has no rights of its own. The family lawyers on the court will be very familiar with the proposition in RMB and the absolutely clear line of authority that the fetus does not have autonomous rights in the United Kingdom. Conscious of the time...
That sounds like a convenient move.
It is indeed. my lids.
Well, we look forward to hearing from you further at 2 o'clock. Court is now adjourned.